Well, as far as the Supreme Court's decision declaring military courts or the trial of civilians by military courts unconstitutional is concerned, the decision is in keeping with the principle that civilians ordinarily ought to be tried by courts of ordinary criminal jurisdiction and that military courts should be reserved for the trial of members of the military, members of the armed forces. Now, having said that, there were certain exceptions in the Army Act, in the Pakistan Army Act of 1952, which did allow for the trial of civilians in certain exceptional circumstances. Now, before we talk about those circumstances, it is important to highlight that notwithstanding such exceptions, the trial of individuals or members of a political party would still not fall within the ambit of those exceptions. Nonetheless, those exceptions allowed military courts to try civilians who were involved in inciting members of the armed forces into mutiny. Nonetheless, while the detailed reasoning of the Supreme Court's decision is yet to be released, certain media reports are suggesting that Section 2 of the Army Act, which provided for such exceptions, has been struck down by the Supreme Court. So in that event, it would be obvious and evident that military courts have been stripped of all powers to try civilians for any offences, and any trials which are currently pending before the military court or any cases concerning civilians which are currently pending before military courts would now cease to exist.